Now, the first of these is the concept of birthright citizenship. Now, birthright citizenship enjoys a lot of currency today. It's commonly accepted. One recent paper prepared for congressmen by the Congressional Research Service stated that, quote, the states and courts in the United States in early America apparently adopted the birthright citizenship doctrine, which is referred to as jus soli, or right of soil. So if you are born in a particular place, then you are a citizen of that place. Now, if you go back and look to the origins of that doctrine in the English common law, you will find that this idea of birthright citizenship is a relic of English or European feudalism. And it didn't have quite the welcoming connotation that it has today. Sir Edward Coke, the English jurist in the 17th century in the very famous Calvin's case, described what birthright citizenship meant. He said, allegiance is a true and faithful obedience of the subject due to his sovereign. This allegiance or obedience is an incident inseparable to every subject, for as soon as he is born, he oweth by birthright allegiance and obedience to his sovereign. Now, this is a reciprocal bond, wherein the subject is obligated to service and obedience, while the sovereign is obligated to protect the subject. One's status is defined by one's birth. So, returning to Coke, who says, they that are born under the obedience, power, faith, legality, or allegiance of the king are natural citizens and no aliens. So what that meant was, you were tied to the land of your birth. Wherever you happened to be born, you were tied to that place, and you were an inseparable citizen of that regime. Now, the monarch or the sovereign owed you protection, but you owed him lifelong obedience. And that was something that you could not sever. The sovereign could release you from that bond, but you could not expatriate yourself. And the reason for that was fairly straightforward. The understanding was, this is a debt that you owe to the sovereign of that nation that you must pay back over the course of your life for the protection that he gave you from birth when you could not protect yourself. Okay, so birthright citizenship then is, like I said, it's a throwback to feudalism. Now, what's interesting is that the American Founding Fathers explicitly rejected this concept. James Wilson, in the early Supreme Court case Chisholm v. Georgia, said, quote, under the Constitution, there are citizens, but no subjects. So citizenship in a free self-governing regime based on founding principles is something different from subjection. The Massachusetts Constitution, which was written in 1780, does a very good job of summing this up. It says, the body politic is formed by a voluntary association of individuals. It is a social compact, unquote. That is to say, political obligation is not the result of birth. It is the result of, or the consequence of, the voluntary consent of free individuals. So it's not something where you're tied to a particular place because of the accident of your birth, but you must, as a rational actor, as a human being with inherent rights, consent or agree to be governed by a particular regime. Okay? Now, the place where you are likely to find the constitutional debate over this issue center is in the 14th Amendment. And it is commonly understood today that the first section of the 14th Amendment confers birthright citizenship on all persons born in United States sovereign territory. But that also is extremely problematic and doesn't represent an accurate reading of that text. Now, Section 1 of the 14th Amendment says that all persons born or naturalized in the United States and subject to the jurisdiction thereof shall be citizens of the United States and the state in which they reside. Okay? But if you're paying attention there are two requirements of citizenship. There are two things that have to happen in order for you to be considered a citizen. You have to be born or naturalized in the United States. That's one. So a natural-born citizen is someone who's going to be born in the United States. Now, there are certain specified exemptions and exceptions in the law to this, but generally speaking, born in the United States. But there's also a second provision, subject to the jurisdiction thereof. Okay? Now, one of the basic rules of constitutional interpretation is that every provision in the Constitution means something. It's not just fluff, and it's not redundant. So one can't say, well, you're born in the United States, and since you're here, you're subject to the jurisdiction of the United States. Well, that is true. If you are a non-citizen, you are subject to the jurisdiction of the United States for as long as you are in the United States. But once you leave, that bond is broken for non-citizens. In the case of citizens, that bond doesn't cease. So if you were to go on vacation, you take a trip to Europe or Japan or something like that, you don't cease to be a United States citizen. However, a non-citizen in the United States, when he leaves the United States, any legal relationship or political relationship between that alien and the United States ceases. Okay? So it's not simply enough to be born in the United States. Subject to the jurisdiction thereof means something different. It's a separate additional requirement, okay, beyond simply being born here. And what they meant by that was that you were not lawfully subject to the law or the rule of any other nation or sovereign or ruler. So that if your parents were tourists from, say, the Republic of Korea, and your mother gave birth to you in the United States. Now, as long as you're here, you're under our laws. But your citizenship doesn't follow the place of your birth so much as it follows your parentage, at least for children. So children follow the status of their parents. The parents, your parents in this case, are lawfully subject to the jurisdiction of the Republic of Korea, and therefore the 14th Amendment's understanding is you are a citizen of the Republic of Korea and not of the United States. Okay? If you look at the intention of the 14th Amendment, and of that passage in particular, the intention was clearly, going back, looking at the text and at the legislative history and the debates over the 14th Amendment, the intent was clearly to confer citizenship upon freed slaves. Persons who were born in the United States, almost without exception, and had no other obligation of citizenship. They were not subject to the jurisdiction of any other sovereign or ruler. Now, if you think about the condition of slavery, it is a kind of feudalism. It's an extreme case of feudalism, but the principle is somewhat similar. That is to say, slaves were born into a particular condition, servitude, and they were bound to their masters, just like a feudal subject was bound to his lord or to his king. And that was a bond that the slave could not break. In other words, a slave could only be released from his obligation as a slave by his master's assent. Okay? This is something that they wanted to reject in the 14th Amendment, to get rid of this in conferring citizenship upon freed slaves. The framers rejected this aspect of slavery, this kind of feudal obligation, so that one representative in Congress expressed the general sense of Congress when he concluded that, quote, "It is high time that feudalism were driven from our shores and eliminated from our law, and now is the time to declare it." Now, this was stated by one of the representatives in Congress, and again, it expressed the general sense of Congress during the debates in the 1860s on the 14th Amendment. They were explicitly attempting to get rid of this notion of birthright obligation. And this was not a radical thing to get rid of birthright obligation. What the authors of the 14th Amendment were attempting to do was to extend to freed slaves the natural law conception of citizenship based on free consent, free association. One example of the way in which citizens differed from subjects was that citizens possess a right of expatriation, that is to say, the right to leave. Slaves didn't have the right to leave, and feudal subjects of a feudal lord did not possess the right to leave. Congress, at about the same time they passed the 14th Amendment, passed a bill called the Expatriation Act in 1868, which declared expatriation, the right to leave, to be, quote, "a natural and inherent right of all people." This view, taken in the 1860s, explicitly follows Jefferson's understanding of the natural right of individuals to leave one jurisdiction, settle somewhere else, and either establish a new regime or become a citizen there. So in the Summary View of the Rights of British America, which Jefferson wrote in 1774, he says, quote, "Our ancestors, before their emigration to America, were the free inhabitants of the British dominions in Europe, and possessed a right, which nature has given to all men, of departing from the country in which chance, not choice, had placed them, of going in quest of new habitations, and of there establishing new societies, under such laws and regulations as to them shall seem most likely to promote public happiness." The 14th Amendment was not radical. What was radical was the founders' rejection of feudal obligation, of birthright citizenship. They were explicit about it. And there are many more examples of statesmen and thinkers from the founding rejecting feudal obligation and birthright citizenship. So the question is, how did we get it back? If it's not in the founders' thought and it's not in the Constitution, what happened? Well, what happened was the Supreme Court. And the United States Supreme Court, towards the end of the 19th century, in a case called United States v. Wong Kim Ark, involving the case of a person of Chinese extraction who was born in the United States but left the United States and then was denied the right of re-entry to the United States under the Chinese Exclusion Acts, and then sued claiming, "I'm an American citizen." And the court in this case sided with Wong Kim Ark and said, yes, he is a citizen. The justice writing the opinion, Horace Gray, says, quote, "Birthright citizenship, which had been in force by the law of England for the last 3 centuries, beginning before the settlement of this country, was in force in all the English colonies upon this continent, down to the time of the Declaration of Independence, and in the United States thereafter." In other words, what the majority in the court did in the Wong Kim Ark case was to ignore all of the documentary evidence that established the contrary, and simply to assert, oh yes, birthright citizenship was obviously what the founders meant. All they were doing was carrying forward the English common law. Now we know that to be patently false. As I said, the documentary evidence, the legal evidence is massive in the other direction. The court in this case simply chose to ignore it, and since then we have accepted the court's decision. Uncritically, or mostly uncritically, and so now we have the principle of birthright citizenship. Now, interestingly enough, 15 years earlier, Horace Gray, the very same justice who wrote this opinion, authored an opinion in another case where he denied the idea of feudal obligation and affirmed the founders' conception of citizenship based on consent. Okay, so that's one issue, the problem of birthright citizenship.